Presidential Decree 968, Section 1, Title and Scope of the Decree. This decree shall be known as the Probation Law of 1976. It shall apply to all offenders except those entitled to the benefits under provisions of Presidential Decree number 603 and similar laws. Section 2. Purpose. This decree shall be interpreted so as to A. Promote the correction and rehabilitation of an offender by providing him with individualized treatment. B. Provide an opportunity for the reformation of penitent offender, which might be less probable if he were served prison sentence. Or C. Prevent the commission of offenses. Section 3. Meaning of terms as used in this decree. The following shall, unless the context otherwise requires, be construed thus. A. Probation. It is a disposition under which defendant, after conviction and sentence, is released subject to conditions imposed by the court and to supervision of probation officer. B. Probationer means a person placed on probation. C. Probation officer means one who investigates for the court a referral for probation or supervises probationer or both. Section 4. Grant of probation. Subject to the provisions of this decree, the court may, after it shall have convicted and sentenced a defendant, and upon application at any time of said defendant, suspend the execution of said sentence and place the defendant on probation, and upon such term in condition as it may them best. Probation may be granted whether the sentence imposes a term of imprisonment or a fine only. An application for probation shall be filed with the trial court and with notice to the appellate court if an appeal has been taken from the sentence of conviction. The filing of application shall be deemed a waiver of the right to appeal or the automatic appeal of pending appeal. Granting of denying appeal shall not be appealable. Section 5. Post-sentence investigation. No person shall be placed on probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice, the ends of justice, um, the best interests of the public, as well as that defendant the defendant will be served will be served thereby. Section 6, form of investigation report. The investigation report to be submitted by the probation officer under section 5 hereof shall be in the form prescribed by the probation officer, by the probation administrator, and approved by Secretary of Justice. Section 7, for submission of investigation report. No, period for submission of report. Tama. The probation officer shall be submit to the court the investigation report on a defendant that not later than 60 days from receipt of the order of said court to conduct investigation. The court shall resolve the petition for probation not later than 5 days after receipt of said report. Pending submission of the investigation report and resolution of the petition, the defendant may be temporarily allowed on liberty under his bail filed in the criminal case provided. The court may allow the release of the defendant on recognize of the custody of the responsible of the community who shall guarantee his appearance for required by the court. Section 8, criteria for placing an offender on probation and determining whether an offender may be placed on probation. The court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. Probation shall be denied if the court finds that A, the offender is in need correctional treatment that can be provided most effectively by his commitment to an institution, or B, there is under the period of the offender will commit another crime. C, probation may differentiate the seriousness of the offense committed. Then section 9, disqualified offenders. The benefits of this decree shall not extended to those A, sentenced to serve a maximum term of imprisonment of more than 6 years. B, convicted any offense against security of the state. C, who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day, or in a fine not less than 200 pesos. D, who have been once of probation under the probation of this decree, who are serving sentence at the time of substantive probation of this decree will become applicable to section 33 hereof. Section 10. Conditions of probation. Every probation orders issued by the court shall contain conditions requiring that the probationer shall: A. Present himself to the probation officer designated to undertake his his supervision at such place as may be specified in the order within the 72 hours from receipt of said order. Report to the Report to the officer at least once a month, such time and place are specified by said officer. Then the court may also shall require probationer to: A. Cooperate with a program of supervision. B. Meet his family responsibilities. C. Devote himself to a specific employment and not to change his said employments without prior approval probation officer. D. Undergo medical, psychological, or psychiatric and examination and treatment and remain institution required for the purpose the training. F. Attend or reside a facility establish instruction or residence a person of probation. G. Refrain the visiting houses of ill repute. Then H. Abstain from drinking intoxicating beverages to excess. I. Permit to probation officer and authorized or social worker to visit his own home or work. J. Approval. G. Reside at okay. So